All right, buckle up because this case is about repeated mistakes pushing the justice system to its limit. The defendant in today's courtroom, Dustin Drake, isn't dealing with his first drunk driving charge, not his second, but potentially his fifth. Now, the judge is facing a serious question. At what point does giving someone another chance stop making sense? And prison becomes the only option left.
All right, sir, are you Dustin Drake?
Yes, ma'am.
And Mr. Drake was previously in court. You entered a plea of guilty to driving while intoxicated, third or more. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
We have, and we have no objection.
Yes, Your Honor, we reviewed it.
And there was no agreement, Mr.
Quick legal insight here. A pre-sentence report, often called a PSI, is basically a deep investigation into the defendant's life. It looks at everything: criminal history, job record, substance abuse issues, family support, and overall background. Judges rely heavily on these reports when deciding a sentence. Because sentencing isn't just about the crime itself. It's also about the person standing in front of the court.
Lane, you may proceed.
Thank you, Your Honor. I guess in situations like this, the PSI pretty much laid it out. So, I don't know if Mr. Drake can be any more sincere than he was. I think the PSI officer got that from him. Most of his allegations were DWIs. After this allegation, we know he entered treatment. He went through almost 18 months worth of treatment. He stayed sober. He's gainfully employed. He's moving forward. He knows that the court has a tough decision.
And the defense strategy here is pretty obvious. They want to convince the judge that the man standing here today is not the same person who kept getting arrested in the past. They're highlighting treatment programs, sobriety efforts, and steady employment. These are classic arguments aimed at persuading the court to choose probation over prison.
I think he said it best in the recommendation where he was. I think he can be successful. His attitude's there, his groundwork is there, his mother's here, the foundation is all there to be successful.
Mr. Nichols?
Judge, this is his fifth DWI conviction, not counting two that were dismissed somewhere along the way. I left when we formulated this plea offer.
And then we reach the number that changes the entire conversation. 5 DWI convictions. In many states, once someone reaches that level, the court stops looking at the incidents as isolated mistakes and starts seeing a pattern of dangerous behavior.
I left it as a count one plea to limit some exposure, but I think pen time is where we're at. I get, and I'm glad that there's what appears to be sincere attempts at getting treatment and doing all that, but the fact is, he hit a car, and this night he was .27. Luckily, no one else was hurt, and I just can't fathom letting him back out on the road, Judge.
And that single sentence, luckily, no one else was hurt, carries a lot of weight in courtrooms like this. Because judges don't just look at what happened. They think about what could have happened. What if another car had been there? What if a family had been driving down that road? Sometimes the sentence reflects not just the crime itself, but the tragedy that almost happened.
So I would urge the court to exercise the full 10 years.
Mr. Drake, other than what's in the PSI that you stated, do you have anything else to add?
No, I really apologize for what I did. I know it was wrong. I am an alcoholic, and I do believe I can finish the probation. I'm not going to sit here and make excuses for my actions because there are none. My record speaks for itself. I'm embarrassed and ashamed.
And I appreciate that, and I appreciate you not trying to make excuses. And I appreciate that you've gotten treatment. The time for treatment was before your fifth DWI.
I agree.
You know, you've had every opportunity since, it looks like, 05, 19, 2021, well, 09, then 10. I guess part of what I'm looking at right now is that there was a short probation from Louisiana some years back, 6 months. But other than that, there's never been, you've just gotten time, correct?
Yes, ma'am.
Okay, here's what I'm gonna do, Mr. Drake, and I hope you take advantage of what I'm about to do. Just based on several of the factors, the age of some of the history, the fact that you've gone into treatment already, I'm gonna give you an opportunity, but you're not going home today. So here's what's gonna happen. I'm gonna find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time find you guilty. Sentence you to a term of 10 years in prison, but I'm going to probate that. You'll be on probation for 10 years. I'm ordering that you pay a $2,000 fine, and I'm ordering that you follow all of the rules and conditions of probation. The first one of those conditions is that you're going to enter and successfully complete the SafeP program. It's a 6-month in-custody program. It's the longest and best we have, and so at least that gives me some knowledge that you have some further treatment and some long-term treatment. When you're released, you will go through the JCDI program as your outpatient follow-up care, which is an intensive outpatient treatment. You will be required to have an auto-ignition interlock device on any vehicle that you drive. I'm also going to order, at least for some amount of time, at the, I don't know how long, but you will be ordered to wear a scram device as well. That is a device that is on your body that shows if there's any alcohol in your body. If there is a positive sip of alcohol, your probation is going to be revoked and you're going to be facing that 10 years that I just gave you. So I didn't give you up to 10 years. I just gave you 10 years in prison. If you violate this probation, don't come in and start negotiation for something less. It's 10 years. Do you understand? So you'll have the scram, the auto ignition, SafeP, JCDI, and any other conditions that probation deems would be important for you to be successful. So this wasn't an agreement. You do have some rights to appeal. I'm handing you the trial court certification. Well, it shows that y'all waived the right to appeal on this. So
That's because we did have an agreement.
you did have an
Go on
agreement.
Count one, you're on.
Correct. So you have waived your right to appeal because the state made that concession that they went forward on count one only. I've also handed you the trial court certification or admonishment that shows that that because of the judgment entered against you, you're ineligible to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term. You should read the written admonishment I provided you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Lane. Obviously you're going into custody, but I am ordering as a condition of that probation, it's mandatory 10 days upfront time, so you'll get that credit while you're waiting on safety. All right, you can go back with the bailiff.
Okay, can I speak from, I'll go run a poll.
Yeah, go with the bailiff.
Thank you, Your Honor.
Yes, sir.